Good evening to all participants. There are judgments, and then there are judgments that leave an indelible imprint on history. Tiger Global judgment by the Honorable Supreme Court belongs to the latter category. A landmark judgment by any account that will surely leave its mark on international tax jurisprudence. The court's observations on treaty benefits, treaty abuse, TRC, sufficiency stroke insufficiency, GAR, substance doctrine, interpretation of Vodafone ratio, and above all, ushering in the concept of tax sovereignty, deserve a nuanced reading. Who better to take us through the judgment fine print than Additional Solicitor General N. Venkataraman, the man who pulled off this big win for the Income Tax Department? Ashish Agarwal, then MFN, then Rajiv Bansal, now Tiger Global. Mr. Venkataraman is a juggernaut, and that's no exaggeration. His extraordinary courtcraft and litigation strategy has helped the tax department in case after case. With Tiger Global, though, he joins the pantheon of legends at the bar. Lest anyone forget, of his 36 years at the bar, Mr. Venkataraman has spent 31 years arguing for taxpayers. The last 6 years, though, have been on the other side, and the impact has been seismic. Among the youngest counsels at that time to be designated a senior advocate, I think a little over 2 decades ago, Mr. Venkataraman has contributed significantly to development of tax jurisprudence in India, both indirect and direct tax. He is also representing PSUs in high-stakes corporate and commercial law matters, including competition law, IBC, and international arbitration. With this brief introduction, I'll be handing over the mic to ASG sir in less than a minute. Quick hygiene announcement. I know there'll be a lot of questions. Please post them in the Q&A box. I can't promise we'll be able to take all of them, but we do understand that that everyone wants answers from Mr. Venkataraman. We'll try to get as many questions as possible. You'll have to leave the discretion to me today to ask the questions. So I'll try to be at my best while choosing questions so that everyone benefits from ASG sir's answers. And I think this webinar may last a little over 90 minutes. ASG sir will take us through different portions of the judgment and what it means. I think everyone wants to understand what this means. It's truly an epoch-making judgment from the Supreme Court, and Taxsutra has been getting you roadblock coverage for the last week or so, and we are committed to getting you a thorough analysis of the Supreme Court judgment, its implications, its fallout, and what it means for the tax world. ASG sir, profuse thanks for joining this webinar. Looking forward, we all are looking forward to hearing you. It's an absolutely full house.
Can I start, Arun?
Sure, sir.
Sharada Sharadam Puja Vadana Vadanam Bujai Sarvata Sarvata Smakam Sannitim Kriya. Dear Arun, Anju, and the Taxsutra team, thanks so much for hosting this evening to benefit first the very speaker in trying to connect with all my old friends whom we all know each other for more than 2 decades. At the outset, let me thank all the participants who have joined this gathering. Right now, it is showing close to 900 people. Very obliged. The trust you have in me that we will speak something which is important to all of you makes us feel very happy and, more importantly, very responsible. So we'll try to do our part of responsibility to the best of our ability. We thank all of you who have joined from the trade, from the profession, from the chartered accountant firms and my chartered accountant friends, individual lawyers, senior counsels, and more importantly, people across ministries who are involved in policy making and making economic choices. This time there has been an endeavor that they should also be on board to understand what was government's philosophy for a decade. And has Supreme Court interpreted it in line with the government's philosophy? And how does trade understand it? How does the consultancy and the advisory world understands it? How it has been projected so far in various places? And intrinsically, what the judgment actually seeks to say. So that it has been kind enough to all the ministries who are connected with this matter, and not only ministries, some of the economic institutions, some of the planning bodies, some of the leading economic households. So thanks a lot for joining this evening. So it's a very, very balanced crowd across spectrum, wanting to understand what this judgment means from our perspective. If we have to reach to tribal global of 2025, 2026, we must understand 30 years of its history and the point of conflicts and the disputes which reached the doors of the Supreme Court in the form of Tiger Global. Unless we speak about that first, we will, if you take off from the judgment, it'll take you in whatever way you want to understand it. So, history of the growth of this law, culminating as of now in Tiger Global, will make it holistic, make it pragmatic, make it penetrative, and more important, clarity. So let's understand the first judgment which spoke about treaties. A very big judgment which all of us have celebrated and continue to celebrate, the Azadi Bachao. Now, what is the backdrop of Azadi Bachao? You must understand, this is a judgment delivered by the Supreme Court in 2003 against proceedings initiated in 1999, where public interest litigations were filed first before the Delhi High Court. For what? Before 2001, Mauritius never had a global licensing systems or an FDI investment through various countries like India. That which was discussed in Azadi was under the MOBA Act 1992, Mauritius Offshore Business Act 1992, which prohibited the FIIs and the rest of the investing community through the SEBI from earning a copper of income in Mauritius. So it is the foreign institutional investors and other investment funds. Other investment funds would only mean those funds recognized by SEBI. These were the two where department initiated action. And public interest litigations were filed against them saying that, look here, if there's a share investor in India, he has to pay capital gains tax. If somebody is sitting from Mauritius and doing it, he needed, this is arbitrage. This is discriminatory. Azadi even remotely did not deal with an FDI investment or an FPI investment because there was no such provision of law in operation in Mauritius. We can't forget basic facts. And Circular 789, you may read it any number of times. Please read it with looking glass. Any number of times. That circular has been issued only for foreign institutional investors and other investment funds. Not for this business investments at all. Because there was no occasion for them to deal with such a situation. And if we say to you, you should not mistake what is the law of this country. A judgment is only what it decides on the issue before it. So, Asadi era is an era governing FIIs and other investment funds governed by SEBI. It had not remotely discussed this FDI investments at any point of time. And 164 of Asadi and judgments within Asadi says even there, king of corporate wheel, fraudulent transaction, this transaction, that transaction, it created so many exceptions. Even in that, when it comes to the analysis of law and the general composition of law in India. So the first milestone is Asadi has its use and relevance along with Circular 789 only for FIIs and institutional funds, investment funds. What is wrong in making that submission to the court? Question number one. We'll finally connect all the mislinked links one after the other. In what way the matter was heard is something which all of you should know. So this is part one. Part two. Between 2001 and 2007, Mauritius started to evolve statutes. You had the Income Tax Act 1995 that is separate. They wanted to bring what is called the Financial Services Act, and it finally settled in 2007. There were prior articulations in 2005 to some extent, and to begin with in 2001. But final settlement is 2007. When they brought the financial, this is part two. When they brought the Financial Services Act 2007, there is one section called 73(1)(b) of that act, which relates to income tax. It says, for the purpose of income tax, if a Mauritian entity has to be recognized as a resident, control and management should be in Mauritius. How many judgments has considered this act? So, there is an underlying law in Mauritius which obligates control and management to be in Mauritius. And by clause 2, it specifies 5-6 conditions, one of them being the management and the control should be efficiently done from the soil of Mauritius. This is part 2. In 2010, India started to work its working papers on GAR. Before that, our Supreme Court constitutional bench in McDowell has always implemented JAR. So, substance over form, lifting of corporate wheel, all these control and management, you must read Justice Chagla's judgment, which has been so with reverence referred to in the Manohar Sarovar judgment of the Honorable Supreme Court later in time, about 2-3 years back. You must read Justice Chagla's judgment on control and management under the old Act. These are all ingrained philosophies in our Act. So there was a discussion started to happen from 2010. Now we'll go to part 3, the Vodafone era. Dear friends, you have all been gluing Vodafone and reading Vodafone left, right, and center only from para 311. TRC, and put 10 exclusions. How you can't touch this, how you can't do this, how you can't do this, how. putting a very humble question before this gathering. Very, very humble question. Please touch your hearts and tell me, was Vodafone dealing with an India-Mauritius treaty at all? Was it doing a transaction in India-Mauritius? So where was the need for 311? Was the question we posed. A judgment without an underlying facts, an academic study, a ratio, an arbiter, academic. No underlying facts. It did not deal with Vodafone, dealt with Cayman Island issue. A share sold from Cayman Island. It never dealt India-Mauritius treaty. So where was the occasion for one of the judges to write a separate opinion on India-Mauritius? See, we have to introspect. But I put a larger question to you now. It's not as though the entire judgment is about India-Mauritius. Then you are mistaken. It is a unanimous verdict, and two of the judges, led by Justice Kapadia, authored a separate opinion. And what did the learned judge say in that opinion? We have relied on, now people are all saying, this is contrary to Vodafone. It should go to 3, it should go to 5, it should go to 15. We have relied on Vodafone and succeeded in this matter. We have not got over Vodafone. We relied on Vodafone. How and why? Vodafone, from paragraph, after discussing McDowell, after resolving the dispute between 4:1, whether it's 4:1 or 5:0, all that, after resolution, all of that, made three things very clear in the judgment opinion by two learned judges. Making it clear, look here, substance test is mandatory. Head and brain test, control and management can be verified. You can't say because you had a treaty or you had an understanding, you should not do it. You can go ahead. And it actually brought 4 important takeaways through that judgment. It says, if the competence of the directors of the subsidiary are transferred or a decision making has become fully subordinate to the holding company, that they are mere puppets, that may be a good ground in identifying the place of residence as that of the holding company. Ladies and gentlemen, I'm not reading Tiger, I'm reading Vodafone for your just information. 2. If the form and legal substance without reasonable business purpose is found to be there, you can take and find out what is the economic substance. 3. If an interposed entity is a colorable device for distribution of earning of profits, gains, lifting of corporate weal is permissible. 4. If there is no commercial or business substance and entities are only interposed to avoid taxes, then apply the test of fiscal nullity. Revenue is entitled to ignore the entity. I'm reading it from the Vodafone judgment. So two judges, after narrating all these principles, give a finding of fact in Vodafone's case that because they held only 42% and based on other attendant circumstances, they enter a finding of fact that the control and management was not elsewhere. That is the finding of fact which they had arrived. Every case is based on, it turns on the facts. So, two of the judges have retained JAR and have suggested GAR is the way forward. Legislate it. India can still apply JAR, no problem, but please legislate it. Consider legislating it. Has been the suggestion in that judgment, an observation in that judgment. So, I'm putting a humble question to the gathering. You have two judges who says control and management is a valid test. Lifting of corporate wheel is a valid test. Economic substance is a valid test. And one opinion which decides India Mauritius without an underlying fact or a transaction. So which is the ratio, which is the arbiter, and if there is a conflict between the two, which would apply? And even in the separate opinion, para 311 says one thing, 312 to 314 says something else. So, to show the magic wand, TRC is all conclusive because of 789. It's a derivative without a legal basis, even prior to. In fact, Tiger Global has resolved it so beautifully, and it has given some sort of saying that we'll move from the law from 2012 post amendments. It could have moved even backward in this context. So you have an Azadi, which was not FDI. You had development statutory laws in Mauritius in 2011 obligating for the purpose of income tax, X, Y, Z. You have a Vodafone which approves JAR and recommends CAR. This is stage 3. Now we will come to stage 4. Post the Vodafone judgment, 3 important amendments took place simultaneously. This under the same finance bill. One, the retrospective amendment of Vodafone, which became prospective in 2021. And we don't have to worry about that in these transactions. These are all investments going ahead for the future. So that doesn't in any manner affect us. This is one amendment. 2, the introduction of CAR. And section 97(1) subclause 4 and 97(1)(c) deals exactly transactions of this nature. So there is a statute which deals with it. Second stage. And 3, the amendments to section 94 and 95 in 12, in 13, and the postponed 1/1 assessment year, and the revised amendment of 95. So, what do these 3 amendments cumulatively take one forward in law? Azadi dealt the situation of FIIs and investment funds. Vodafone, though not a treaty-based transaction, it dealt with an FDI FIP investments. These 3 amendments dealt both the situations. It dealt both the FPI situation and also the FII and the investment fund situation. It went through GAR, identified these types of transactions, if it is found to be factually so, as impermissible agreements, and introduced how to deal with them also in red with Rule 10U as far as these transactions. When it came to FII and investment funds, when it brought 94 and 95 in its original form, there was a lot of protest. And therefore, it had to necessarily realign itself in a modified form of 95 to deal those transactions. Because The same 2012 Act also brought 92A, namely treaty override. So you had a Vodafone, which was amended retrospectively and later prospectively. You introduced GAR. You introduced 92A overriding tax abuse. GAR will override treaties in line with several countries. We have put all those, we at least gave some 12, 13 examples to the court where there is a treaty override clause in the various statutes. And what are the basis? We'll come to that in a little while. And fourth, 94, 95, and the realignment to ensure that the FII and the investment fund markets don't go nervous. You can't say after the introduction of GAR, especially after the introduction of 10U, you will still bank on 94, 95 and TRC, which is applicable for FII and for investment funds. So, typically, 4 important amendments was ushered into in 2012. And between 2012 and 2017, several attempts have been made by the trade. You had the Shum Committee's recommendations. You had the press release in 2013. You had a press release in January 27, 2017, where they were not prepared to call all this as only investments forever. They made a distinctions. Investments will be grandfathered. Arrangements will not be grandfathered. They made these two expressions vividly clear. And they gave the reasons. If you do that, if you walk that path, what will be the consequences as decided even by the Select Committee in 2010? So you had tried your luck. This is the 4th stage. You had tried, you had knocked the doors of the government, wanted them to grandfather, and you didn't succeed. The letter of the law has not, the fine prints of the law has not assimilated your aspirations. Now, this is the 4th stage. So, how do you say everything is only an investment? No, please read 10U subclause 1. We'll go by your own logic. Subclause 1 has 4 subclauses, A to D. You read subclause A, it deals with the expression arrangement. Threshold arrangements less than 3 crores are ignored. It won't be brought under GAR. So there, the usage of the expression in 10U1 subclause A is arrangement. Whereas 3 subclauses down, subclause D, the expression used is investment. Investment which do not get colored needs to be grandfathered. So there are 2 buckets, 2 possible buckets of business transactions. An investment transaction, even after scrutiny, suppose the same tiger blows and proves because it is only at the threshold stage. If it proves its case as a genuine arrangement, investment, it will fall under subclause D. If it fails the test and it becomes an arrangement, then 10U2 says without prejudice to clause 1D. You say it should be notwithstanding, it should be XYZ. You didn't like this, you don't like that expression without prejudice, and therefore it should not law for you. It emasculates and eclipses 1D and say arrangements will only be dealt under U2. And is this, Supreme Court specifically asked us, is this one of the arrangements as declared in the statute? We show 9714 and 971C. Directly dealing location of the resident, location of the property, location of the assets. Clear, unambiguous and uncertain terms. If it is found to be on facts. So, when these 4 cumulative happenings converge. Fifth point, before we go to global on facts, fifth point, what is the global understanding of these types of laws? Because when anybody other than our Supreme Court, anybody other than our government, anybody other than our councils or others, if somebody else speaks, then it's fine, it's acceptable. So what do these somebody say? Internationally, we have produced before the court the Vienna Convention of Good Faith, which says source country, three rules, all over the world they follow. Source country has the right to tax. Through a contract, you can allocate treaty rights. Rule 2. Rule 3 is where if you stop there, game is over. But there is a rule 3 all over the world, which is what is being now reflected in this judgment. Rule 1, source country the right to tax. Rule 2, allocation of rights through treaties. Rule 3, if it is a transaction of tax abuse, source country has a right to legislate and override treaties. Who says this? Vienna Convention says this, not our Supreme Court before that. Who says this? Clausewel says this. Who says this? OECD commentary says this. Who says this? Jurisdictional jurisprudence in few other countries have said it. Who says this? Actively, several countries have legislated and made it very clear God will override treaties as a matter of practice. Before Supreme Court laid down Tyler Global, there is formatted global practice based on these 5 footprints. All the 5 footprints were placed before the court. And in this background, let's now read Treaty, GAR, 13.4, 13.3, all that one after the other. Because first concept has to be very clear. And therefore, these 5 parts needs to be first presented to the listening audience. You can note down your questions, you can raise your questions on these 5 parts anytime. Willing to answer, no problem. Now, we will go into Tiger. Anti-investment, anti-India. India will go into Stone Age, Dark Age. Many things are said here and there. Let's understand what are the factual metrics in Tiger. The resident entity sold the Singapore shares which had a direct interest in India, which is something all of us know. So in every share purchase agreement, there is a seller and there is a purchaser. And what does this share agreement say? It clearly says, it puts several contingency factors in terms of Indian income tax. There's a possibility for this to be called as a transaction which is liable to withholding. It carves out 1, 2, 3, 4, 5, 6. It clearly says the purchase is under obligation to absorb the TDS. It clearly says within what frame of time you should give evidence for payment of the TDS. Documented in the SPA. Agreed between the contracting parties. Typical facts we are presenting to all of you to understand what is the case. Now ask a question to yourself. You're all saying it is anti-investment. Everybody will run away. Look here. it is not only that they signed and inked contracts and signed it. They took it forward by going to a tax officer and asking whether this is liable to TDS. Step 2. So he passed an order, provisional order, saying you have to pay 6%, 7% for 3 entities with varying rates between 6 and 7. So if India is an anti-investment destination, according to all of you, then Tiger should have pulled out the investment out. Look here, this is a bad country here. Don't go on investment. They are putting TDS on us. Get lost. We will not invest. We will not buy. They didn't say that. They didn't say that. Instead, they went on with the investment and started to litigate the TDS, going to AAR, going to Delhi High Court, and finally reaching the Supreme Court. With folded arms, we are asking a very humble question to you. How do you say it is an anti-investment decision by an investor? I just want to know, because so much is said about it. You go to an officer and get an advance, get a provisional order, and you have not pulled the investment back. You have gone ahead with the investment. So your idea is, if you succeed with all your legal genius and expertise, it is 10 more additional 10% profit into your kitty. If you lose, it's the cost of investment, you will make it over to the tax office. This is the journey of this case on facts. And everyone writes anti-investment, anti-India, anti-growth, anti-development, anti-treaty. We are testing a transaction for assessment year 18-19 where God operates. So the first question for the kind consideration of this gathering is, in this typical facts, how do you project a view it is anti-investment? How do you sustain it? Remember, businessmen are always prudent. And somebody was saying, it is like act of God. Very nice. So you go and tell this. If imposition of tax is act of God, then why are we discussing all this? It is God. You have to go and blame God, not the government or Supreme Court for deciding all this. We are dealing serious matters of public importance, of national importance, of global impact. So, this is the factual background. 2, the second most important aspect you should know in this case, when the applicant who applied for TDS went to the AAR, they conceded before AAR, we are governed by 13.4 and not under 13.3 or 13.3b because it's an indirect transfer. Indirect transfer are not governed by the treaty benefit is not. They conceded that fact. But they succeeded in the Delhi High Court. After conceding here, Delhi High Court says you are protected. You are 13.3a and 13.3b. And therefore, there was a necessity for us to argue this point before the Supreme Court to reverse the Delhi High Court judgment because it's wrong, legally wrong. So in this background, let us see what is the ratio conveyed by the Honorable Supreme Court. It says, under a GAR regime, you are entitled to see very clearly the global thinking on GAR is, do not think allocation of rights through a treaty means allocation of tax abuse also to the other country. Very clearly. They are two disconnected phenomena. That is, when somebody has taken the pains to author a separate opinion and talks, which is a surprise to all of us, at least to me, it is a real surprise. In fact, in my personal view, I thought it will be one judgment, whichever way it goes, and it may be possibly be authored by Justice Padiwala. This was the conception, at least I personally had. But it was a pleasant surprise that Justice Mahadevan wrote the leading judgment, and with pride we say that it's such a class, a judgment authored a very classic style. And even more surprising that there was a separate opinion by Honorable Justice Padiwala on taxability. Something very, and see the effort of the learned judge. Where was the need for this? And say, you have not, who was there to say, whoever was present? See, what was argued? Why was this tax sovereignty an issue as contest before the court? Which was spun out as a separate opinion so beautifully and crafted it. It was argued whether tax abuse should be part of treaty or part of domestic law. It was argued very heavily by both sides. Both sides. And international jurisprudence supported us. It said, therefore, why they say it is a sovereign choice? Abuse cannot be allocated to another contracting country. That's the essence of the law. Why should India be different? Just to please you all. Why? Where is the need? It's the simple question we are posing to you. So, treaty is always made in good faith. And therefore, allocation of rights are also made in good faith. But abuse through that allocation of rights is not made in good faith. It is bad faith. And that is why countries are able to assert and evolve GAR as their sovereign right. Dissecting it out, isolating it out of tax treaties. Country after country has done it. India is not the pioneering nation in GAR. We are very late. So if you read the separate opinion of Justice Padiwala on tax sovereignty from the tax abuse perspective, you will arrive at one inference. If you don't want to read it, you will arrive at your own inference. That choice is used with you. So, when you deal with GAR, you need to deal with tax sovereignty. That was the necessity in which this whole concept emerged in the course of the arguments. And therefore, these are the questions we argue while deciding residency under Article 4. Have you bequeathed your right in testing residency when it is an abuse? We said, no, Vodafone supports it. Your Vodafone supports us. Your own Vodafone supports us. Lifting the corporate will is permissible. Substance over form is permissible. Head and brain taste is permissible. Because they dealt, India is prone to jar. Now you have statutorily created jar. GAR. Therefore, abuse of residency is a sovereign right for the source state, is what the judgment, both the opinions have said in convergence. And therefore, to write, to relook TRC is a valid right given to every country. Especially when Justice Mahadevan puts it so beautifully, it doesn't pass the threshold requirement of a binding order. Based on what you give, I'll give you TRC is what? They don't want to take any responsibility. No country takes the responsibility. And you will say it's allocation of rights. You have surrendered your rights. You have ceded your rights. Keep your mouth shut. Leave it forever, eternity. Why? Why? That's not the law. Rest part of the world. See, why should BEPS emerge? Why should SCP emerge? Why should POEM emerge? Why should people all over the world be discussing all this if allocation of rights is all, once and for all? That you have ceded your sovereignty. Sovereignty is inalienable. Please understand, allocation is different from inalienable right of sovereignty. This judgment is a talking point, as an important defining moment in tax history. And all of you say, why should? So, testing residency on control and management, not necessarily only under 4.3, it can be done under 4.1 also, because it talks about domicile, it talks about resident, which are for individuals, it talks about control and management too. If there's an abuse to that, you can crack it. This is one important aspect which now come to 13.3a, 3b, and 13.4. The treaty between India and Mauritius very clearly says alienation of shares of a resident or company of the contracting state. So direct. And rightly, Tiger conceded before the AAR, no, ours is indirect. We will not be governed. Rightly. But they still succeeded in Delhi High Court. Saying, no, after conceding here, it is not giving up. They succeeded. 13A, 13B will apply. And therefore, Supreme Court had to reverse it. It's not our mistake. This issue would not have come up for consideration had the concession continued. Therefore, when it says alienation of shares of a resident company of the contracting state, how will you now say contracting state holding indirect transfers? And you will invite X country, Y country into a bipartite DT and say it is indirect will cover. How do we read all this? And why do you blame the Supreme Court and the law officer for arguing this point and winning? So 13.4 is now what was originally 13.4 is now split into two. 13.3a, 3b, read with LOB 27 for 2 years gestation. So limited grandfathering has been given to India Mauritius. It has not been given to any other. If it has been given to some other treaty, please test the treaty. You are free to do it. So grandfathering within treaty read with LOB conditions has been packaged contractually. And what is the global thinking? If there is an LOB, it does not therefore extinguish application of GAR. To that extent, on that point, there may be overlap for you in your favor. But if the larger interest of GAR of a statute, which considers this as overall abuse, you are gone. Under a GAR, see, the whole, what was shocking for us is, which is very important. The Delhi High Court went that far. How far? One, once there is a treaty, JAR cannot be invoked. That's the finding by the Delhi High Court. So once you cannot include JAR, you will not include GAR also. In fact, four important aspects the Delhi High Court has dealt. That is why we went on a long-drawn battle. I'll just give you the 4 points. What it says, once you enter into a treaty, tax abuse cannot be tested. That's the finding of the Delhi High Court. So, your right to bring GAR is emasculated because you have entered into treaty. GAR is inapplicable for treaty nations. Is the finding by the Delhi High Court. Without, see the beauty, without a challenge even to the provision of law. LOB. Once LOB is there, GAR cannot apply. Three, recommendations of the Shone Committee, etc. Well, it will all override. So all your amendments, including GAR, is gone. JAR stands extinguished when treaty is in place. Substitute JAR with GAR. That's what Vodafone says. GAR stands extinguished when treaty is in place. how does it stand in law? What is wrong in Supreme Court reversing these four ratios? How is it wrong? How is it bad? Now, a few points, and then we can take questions. When it comes to tax abuse and tax treaties, allocation of taxing rights does not result in cessation of dealing. Tax abuse is a universal thing. Two, allocation of taxing right does not result in allocation of tax abuse as part of its allocation. Three, allocation does not diminish sovereignty in examining tax abuse. Otherwise, GAR is unworkable in any part of this globe. Completely unworkable. So, Article 4 is over. 13.3a, 13.3b is over. Now come to 10U 1 and 10U 10UD, 10UD 1A, 1D 2. Let's see the provision for a minute for the sake of benefit of one and all. See, what does it say? 10U1 subclause A says an arrangement where the tax benefit in the relevant assessment year arising in aggregate to all parties to the arrangement does not exceed a sum of 3 crores. So, within 4 subclauses, one subclause uses the expression arrangement. That is A. Arrangement less than 3 crores, even though under GAR we are exempting. Then it deals with FII, protected. Then it deals with the third category. And fourth, now you come to D. When it comes to D, it says I'll just take in a minute's time. I'll read D for in 1 second. I kept it somewhere. Just take D. Yes. Now, subclause 2. Without prejudice to the provisions of clause D of subrule 1, the provisions of GAR, chapter 10A, shall apply to any arrangement irrespective of the date on which it has been entered into in respect of tax benefit obtained from arrangement on or after first. So, how do you say this will go down? This 2 has to actually, you shut your eyes, there is no 2 at all. There is only 1 D. Therefore, everything is only an investment. When the language of the statute uses 2 different shades, one is an arrangement, another is an investment. And it says, what does 10.1UD say? 10.1UA says, an arrangement where the tax benefit in the relevant assessment year in aggregate to all parties does not exceed 3 crores. Arrangement. D says, any income accruing, arising, or deemed to accrue or arise received so and so any person from a transfer of an investment made. See, simple. When something is not an investment, it can be an arrangement under the GAR. It can't be an investment for Rule 10. It has to be an arrangement. It can't be arrangement for GAR, an investment for you. So, when it clearly says such transactions which fall under GAR are not grandfathered under 2, how do you blame the Supreme Court for saying, when you see, you all tried your luck, and government and legislation and parliament and the settled government has not favored you with this concession of grandfathering? Because they were clear that all investments from 2011, 2010 is all done with wide open eyes. You know for sure what the law is going to be. So they said, no, we can't give. That's a policy call. Now you blame the Supreme Court for not grandfathering it. Can a Supreme Court grandfather something which the law has not grandfathered? How do we get all this here? We are really at a pains to understand. can Supreme Court grandfather without law? Because you have advised everybody that it will be grandfathered. How is it possible? Is the question we put in a very, very humble way. Introspect. Don't blame us. If you have taken a wrong decision, if your investor has taken a wrong decision, why do you blame the government? Why do you blame the law officer? Why do you blame the Supreme Court? Where is the need? Is it justified? Where has it gone wrong? Please introspect. Don't push it on us. Don't use your own efforts, your own impact, and start to push us, saying that you are bad, you're literally bad. Why? Why should we take it? Why should we take it? When we have not done anything wrong? Is the question. I leave it to you for your kind introspection and consideration. Now, with all this, there's a lot more to say, but now last 5-10 minutes, and then I'll take questions on tax sovereignty, because that's one important topic. See, this is how I read the judgment. It's up to the court has thought it fit when it deals with the situation of gar of a tax abuse. The dissection between allocation and retention in terms of treatment of tax, so in line with the global order, is only perfect. So while dealing it, it also dealt, considering the phenomena that is happening across. How should a developing nation, how should a competing nation, how should a nation which is now a responsible part of the global play also look at its future? It talks about how small, if you have affirming tax sovereignty, how smaller nations can gather around you for support, which otherwise they either get isolated or they piggyback for whatever they are given. Because see, all of us, though in business and trade and international diplomacy and in economic policy matters, the most powerful will always try to extract more from the less powerful. It's all understood, known. It's not something unknown to anyone. In that phenomena, in fact, in para 17, the judgment beautifully puts in the global, I mean, it's a very well-researched judgment. It says there are 3 types of sovereign secession that appears to happen. It says as a phenomenon. Just read one passage out of it. It doesn't refer to any country, any transaction, any entity. No, it's a concept. Compromising or ceding sovereignty can be in many forms and ways. External pressures and compulsions which can interfere and interdict with domestic policy making. One way. External expectations and pressures demanding a larger than required yield of sovereign compromise. Second way. There can also be a third factor, which is fast emerging scenario. Nations, international bodies, and even multinational companies or the other entries trying to influence or force impactful changes in the tax policy choice of a nation, which may subserve their interest and betterment. So are we not seeing all this all over the world today? Now come to paragraph 19. It directly deals with the BEPS situation. It only says, it is the right of a nation whose soil or source stands used or exploited for generating or earning an income to get the right to tax. The place, location, or the source of earning should also be by default become the place or jurisdiction for taxation. What is wrong? Any arrangement to the contrary is a compromise, yes. So it deals with source taxation as the proximate sovereign right for the nation to tax. Now come to 2021. See, I was told that an application of, taxing this, let me read it so that I clarify it. I don't want to be engaging. There's no time for us to be engaging on one word beyond a point. Taxing an income arising out of its own country is an inherent sovereign right to that country. An application of filters or diffusers to this is a direct attack to its sovereignty, which can affect a nation's long-term interest. If you read it, these 2 sentences in isolation, treaty-making power has been interfered with by the judiciary. Very well. Please read the next para. Next para. It says, besides economic independence, the need power is better expressed when nation is more and more autonomous, so and so, so and so. Better prudence to retain tax. It says, tax sovereignty should ensure itself to match with political sovereignty of the nation and need not be either separated or leveraged any less. Push or pull should be the sovereign's choice and should not be dictated, trusted, or compelled, and this is doable only when tax is retained. Not yielding in tax sovereignty one form of retention of power, protecting its sovereignty for exercise another. Three times. Not yielding one's tax sovereignty is one form of retention of power. Protecting its sovereignty from external pressures is yet another form. But see the third sentence. But a meaningful exercise of choices alone reflects strength and character, and in the long run will help to reap the required dividends. Where does it stop you from entering into treaties? With this sentence, you read one sentence out of context and don't read this sentence. Para 24, 25. If you find time, please see, it talks about dispute resolution, which is what we are doing. It says one sentence, which is exactly what we are doing in income tax under MAP. What does it say? When agreements need to be entered into between nations, either through its legislative or executive arm, dispute resolution should also be part of the same arm of process and should not be diverse or outsourced or pushed to a mandatory arm. Is exactly what MAP proceedings is all about. Something which is currently happening in your act. Therefore, it is in this background Tiger Global Judgment has been delivered. And please now introspect whether government is bad or Supreme Court is bad or what we have argued is bad. Whether all of them have gathered to end your regime of development in India through these processes. Whether we deserve all this from all of you, whoever has contributed in whatever way possible. See, for example, one of the views, very scholarly view, it says in Asadi, it says taxation need not be there. You need not have to pay tax in Mauritius to pay tax here. Whereas Justice Mahadevan has said that, see, the ground rules in Asadi was MOBA Act 1992. You cannot earn a rupee in Mauritius. You're banned. In 2007, the regime has changed under the this Mauritius Financial Services Act. You have to be there. You have to show your control and management. So situations have completely diametrically changed. The underlying substance has changed. And therefore, before we close, it's our duty that a victory of this nature cannot be attributed to any one individual or one person. Lot of people have put a lot of efforts, and I owe, and we as a team, to start with, the Mumbai team led by Malti Sridharan, Vinod Tanwani, Himanshu, Sanjay, and the rest. And in Delhi, we had the help of Mr. Goswami to some extent, to very, very nice, timely help from him in articulating a very important angle. And we also took the help of Vandana Sar, who showed interest on her own that she wanted to involve. And we thank our Ranjan in Mauritius, who was instrumental in giving us very critical inputs overnight. Ask for it today, he'll give it tomorrow. And we had all the necessary backing on the Mauritius statutory process, statutory laws. And when it said investment funds there, what it meant in India, the SEBI connection, all this we could make it out in no time because all of them helped. And more importantly, we thank the Government of India in trusting us in doing this matter. And we are very thankful to the opponents, both Mr. Salve and Poras Kaka, who elevated the scale of this debate to a very, very high intellectual level. Very high. It was astounding. It was so nice to argue a case against these stalwarts. And more importantly, we will remain very thankful for such a defining judgment authored by Honorable Justice Mahadevan. There is an extra pride. He also hails from our court. And to Honorable Justice Padiwala, for the surprised packet of evolving a jurisprudence on taxonomy. This will go a long way in various tax jurisdictions in putting. And so, in fact, one paragraph somebody has written, I was told that it impedes separation of powers and all. I'll find that sentence. See, beautifully, the judge, I'll just find that sentence, beautifully has said in one place. In India, we test it under Part 3, we test it as separation of powers, etc., etc. When it comes to a global phenomena in projection, how these, by respecting the separation of powers, how we can still be aligned and think at a global level. I'll read that sentence, it's worth reading it. I've noted it somewhere. Just give me a minute before you ask the question, I'll trace it down. Such a classic passage has been written by the learned judge on separation of powers, because somebody will raise it somewhere. I got it. See, this is paragraph 10. I'll just read it. Unlike domestic affairs where they are aided by the executive, the legislative builds the necessary laws into motion, and role of the judiciary is only to allow permissible judicial review. Exercise of tax sovereignty by a nation, and as a nation, requires the roles of 3 constitutional bodies to play its significant and within the umbrella of doctrine of separation of powers. The reason being, when a nation front ends its tax policy in the international domain, the role of all the 3 constitutional organs becomes very relevant. Convergence without dilution to the doctrine of separation of powers would add strength and vitality for any democratic nation to exercise its choice of tax sovereignty. Where does the Supreme Court says it's all submerged into the ocean? To say that it's unconstitutional, it's violated of 51, it should go to larger bit. Please see para 10. See, when somebody says something, it is respected because the rest of them may not read the whole thing. There is a responsibility we carry every time when we utter a word. We are accountable to you because you trust us. Trust is more important. And had you all gathered together and shown it as a matter of strength, where we could have been with this judgment, I leave it to your introspection. Once again, thank Arun and Jur and the entire Taxsutra team, and more importantly, 1,400 viewers. I mean, I'm thrilled. It's an honor to the Supreme Court. It's an honor to the Supreme Court. It's an honor to the central government for putting its foot firm on all these policies for over 10 years. With deep salutations to these 2 constitutional bodies. Pranams to all of you for this wonderful opportunity. Thank you so much.
Entirely our pleasure, sir, to host your exposition on this judgment. So I fully acknowledge that you had your backs to the wall while starting this case and pulled this off with absolute aplomb. Yet, sir, there are some 100 questions. We can't take 100, 120 questions. We can't take more than 8 or 10, but I'm trying to pick them. The first one is from me, sir. And this comes from talking to a cross section of taxpayers. The worry is that there would be an indiscriminate application of the Tiger Global judgment by the tax department. So that's the worry.
And I'll answer it in 2 parts. See, at least I am for one, I'm speaking for personally. Any indiscriminate action by anybody, I have not supported it. People who have opposed me in courts know it for certain. If something is wrong at our end, I will be the first person to concede it for you. We are not here to interfere with trade. This government doesn't believe it. We want to facilitate. If at ground level something goes wrong, seriously, please bring it to our. You must have the guts and the courage to bring it to our notice. You don't do that. Every time I'm asking you, bring me a classic case of an abuse by somebody. We will fight for the trade. We give you that assurance. See, this government doesn't want to interfere with trade. As long as you follow the rules of law and you are allowing us to follow the rules of law. If somebody does some aberration in isolation, Deal it separately. And we assure you, if such things happen, bring it to our notice. What possible help we will do for the trade, it will be our duty and endeavor to help you. And whether government is going to come with guidelines on this subject, I have no idea at the moment. And let's see in case they come for a discussion how to. But if the trade, I'll just give you one more option. If the trade has real concerns, these are all transactions which are clinically genuine in your opinion. Don't say TRC will still be valid. That's gone. If you find out, suspect that these transactions should not come under because of these reasons, genuine, see, we are ready to discuss with you. We'll help you in whatever way possible within the realms of law. Have that confidence with us. That is different. But I'm trying to say this judgment should go. This judgment should not be applied at all, and we should forever have TRC, and God should never be applied. It's all not workable. So this is the answer. We assure you that way to the trade. We are all user friendly here. We are sadly mistaken whenever we win cases. We are mistaken whenever we lose cases. We are very friendly. This is the true relationship I've been enjoying with all my colleagues for the last 6 years. I'm used to it now, so no problem. We'll still help you where there is a genuine need. We will be by your side.
I'm reading some audience questions. I've picked 5 or 6, I think, and there have been a lot of repetitions, but these 5 or 6 capture the crux of most of the questions. One, does not the law as laid down by Supreme Court on grandfathering of investments contradict with government's philosophy and require a promissory estoppel? The government may do well to make appropriate amendment in the upcoming finance.
So you want an amendment and you accuse government of promissory estoppel. How contradictory your question is. You can invoke promissory estoppel when already there is a law. You want the law to amend and say promissory estoppel. It's legally inconsistent. But more importantly, on grandfathering, the fine prince of law has not assimilated your aspirations. If something falls under GAR, then it will not be grandfathered. It's the law as it stands today. Now you want the government to retrospectively amend or not, that's a policy choice. But Supreme Court has interpreted the law as it stands today. And you ought to have arranged your business affairs in terms of the law. There is no surprise bracket. There is no shock. There is no something pulling your feet, pulling the rug under your feet. All this has not happened in this case. It's a very open, transparent, fair play.
Yeah. So there are 2, 3 variations of this question, but I'll paraphrase them. One is the judgment only confined to Section 245R, and therefore all observations made on TRC, grandfathering, residency test, indirect transfer are obiter. There are several people who have tried to put that. Another one, which is again connected to this, is can the Supreme Court directly hold an arrangement as impermissible without following the procedure laid
Yes.
down under the statute of the approving panel? So,
I'll answer this. It's a good question. Please read the judgment line by line. This is Mahadevan has very clearly said the AAR has found it to be prima facie. We also approve it as prima facie. We have decided the guiding principles, but go on facts and fight it out. It is still open for Tiger to show that transfer is only an investment and not an arrangement. Supreme Court has not concluded on facts behind their back without an opportunity that this is this or that. While they argued that I have a TRC, that's the end of the inquiry, they said nothing doing anymore. And somebody asked whether 788 is circular is valid even now. Post 2012, definitely not. Prior to 2012, your 788 can still be, in terms of Vodafone, can be tested in terms of lifting of corporate wheel, lifting of economic substance, lifting of control. That is independent.
789.
But post 2010, definitely not.
So that's a very important clarification you're giving, sir.
I'm not giving. The judge has said, the learned
This
judge
is prima facie. You're saying judgment is prima facie right now.
on facts, but on law it is not prima facie. It is
I've understood. So now the entire process, the assessment process kicks in.
Yeah. Uninfluenced. It has not uttered a word on the factual transaction. We have refrained ourselves from doing it. Court has also refrained from doing it.
Okay, but it does say that prima facie it is.
Prima facie, that is, in fact, Justice Mahadevan has referred what is prima facie.
Yeah.
See, suppose prima facie means no view, then what is prima facie view? See, all this has been tested enough a number of times in the Supreme Court. And the Delhi High Court outstretched itself saying that it's a conclusive view. Supreme Court did not agree to it. And therefore, Delhi High Court took it upon itself. No, this is a conclusive view, therefore we'll decide the law. All right, you decide the law, and therefore there is a need to reverse it.
So
Had
theoretically,
Yeah,
so
see,
theoretically, you're saying that Tiger Global could come back to Supreme Court now after this.
on
Theoretically,
facts, on facts, they are entitled to contest, not on law, on the ratios decide. And on facts, they can always contest.
fair point. Uh, Connected, sir, again, is that no reference has been either made by AO nor any GAR approving panel has been formed. So I think you have clarified that point. Said that, yeah. But sir, the question connected. There are several comments here, observations, feedback here that are large portions of the Supreme Court judgment and arbiter and not ratio deciding.
We will fight on that. See, you whatever you think, see, whatever is inconvenient to you, you will call it arbiter. What is arbiter and what is ratio? Is TRC an arbiter? Then you are wrong. Is 13.3a and 13.3b is arbiter? You are wrong. Whether the opinion on tax sovereignty, it could be an arbiter.
I think so. I think many may possibly be grappling with how to decide what is a ratio and what is arbiter. I think the inversion test has to be applied, and if you and any could the judgment have been written or portions of the judgment have been written without referring to certain facts, and I think that answer would be very clear. So I'm surprised at this question actually.
Yeah.
Would you be fair, sir? The inversion test will have to be applied on this part.
No, I answer it more clinically for the sake of clarity. See, the judgment authored by Honorable Justice Mahadevan is a ratio which is a joint opinion because he has authored it on behalf of the bench. The judgment authored by Justice Padiwala is their own observations. It does not deal any particular treaty, particular transaction, particular investment. It says what is the all-around scenario and how do nations position themselves when it comes. So what is the power of tax sovereignty? What can tax sovereignty do to a nation? You should all spend time to read both the judgments very carefully. The finding portions of Justice Mahadevan and this, both put together. It's a 150-page judgment. But these two portions put together will only be 30-35 pages. It's worth reading it. The time spent by Justice Mahadevan in dealing with 4 issues he has decided. On the test of Article 4, on the substance test, head and brain test, everything will apply. And remember, for Vodafone, they succeeded on all these tests. In Tiger, they may fail in all these tests. That's the prima facie. On law, therefore, you can apply is the law.
Sir, this one is quite interesting. What is the difference between investments and arrangement? Referred to in Rule 11.
There's no difficulty at all. See, an investment which is not an arrangement, it passes through the filters of arrangement and getting tested and regard and comes clean, continues to remain as an investment. You have the right to prove that your transaction is genuine. It is not for tax avoidance. Then it remains an investment. Suppose it passes through the filter of GAR and fails in the test, then it ceases to be an investment. It becomes an arrangement as an impermissible avoidance transaction. That is why Rule 10U within same subsection uses both the expressions. So for you to say, no, anything that is invested in India prior to 2017 will always partake the color of only investment, is you are foreclosing the option of applying GAR, which government has not approved it in the law. and therefore Supreme Court could not approve it by a judgment. Simple.
So, couple more questions. One, and several people have again asked it in different manner. Uh, I'll put this one. For claiming of DTA benefits, is it mandatory to pay taxes in the resident country?
Claim DTA.
To
As
claim
long
DTA benefits, is it mandatory to pay taxes in the resident country?
Now the answer is this. Resident. See, now when the observation was made in the light of three developments, which was not so in Asadi. I failed to say that also. One is this 2007 amendment to the Financial Services, Mauritius Financial Services Act. Second, more importantly, there is in 2018 and 2019 amendments were carried out in the Income Tax Act, bringing the substance test, bringing the test. Now, three, when you say payability, taxability, it is similar to exemption. If something is taxable, you have failed to pay and you are claiming here, then it's okay. If something is by default an exemption there, and then you claim a also an avoidance here, and if it comes to be a genuine transaction, you can't touch it. Justice Mahadevan doesn't say there. But if it's an ingenuine tax abuse transaction, then you can touch it. That is how you have to read this sentence in the holistic path. You can't see, if you take one sentence out and then start dealing it in a way, you can arrive at your own inferences. In the holistic part, one of the text for tax abuse is if something is payable and you don't pay, and you also don't pay through a tax abuse mechanism, then don't bring tax treaty as a shield. It won't help you any longer. It's the ratio.
Sir, this one is again interesting. Whether FII, since you mentioned that this case deals with FDI, does it mean that FIIs will continue to get grandfathering benefit and continue to rely on Circular 789?
Now they are protected under 10U1B. Please read 10U1B. That's why I'm saying. That is why this 2013 press note, 95 amendments, all this is akin to 789, which was only for FII. You presumed 789 is Panesha. It's like universal application. Whose mistake? It's our mistake or your mistake? So from 789, post 2012, post 2012 95 alignment, press note of 13/2013, and the protection given under 10U1B, it's all in sync here. It's so well crafted legislation. Whoever has authored it has done a very good job. One set is continued to be preserved in terms of Asadi even today. One set has been taken out from the beginning. Vodafone is the first lighthouse. That judgment has carved out in the two-judge opinion. And you are relying on 311 and India Mauritius, which according to us, all of us, is an arbiter which has A, Y, B, or which also puts caveats on a transaction which was underlying transaction was not India Mauritius. Please answer it. Was it India Mauritius? And there are two, if you say take both the judgments, 2:1 within the judgment, 2 says you can lift corporate veil, you can lift substance veil. So you can, treaty abuse can always be examined.
Okay. Sir, several questions on one point, whether what will be the fate of indirect transfers going forward under treaty?
As per this judgment, no, this is a point they consider they should not have argued at all for you to got. See, it was their invitation, we had to respond. So I'll give a specific answer. Supreme Court has now held 13.3A and 13.3B will apply only for direct transfers. It will not apply for indirect transfers. That's a clear ratio emanating on the judgment. Because the erstwhile 13.4 has now been split into two parts, direct and indirect. And protection with LOB is only for direct.
So this comes from one of the doyens of the tax profession, Mr. Yogesh Tar. He asks, if TRC is there, how will a deductor decide whether the pay is resident of that country or not.
See, then why should you put in your contract several caveats? Your TRC may be susceptible to attack. Your control and management can be questioned. So all this, you are putting it very, very clearly in your agreement and say that you please approach the tax office. If there's a TDS payable, pay, give me the certificate. Why should you say all this in your agreement? See, let's be very clear here. Businessman understands this 10% very differently than the advisors. And he packages contractually the safety valves. And if they win, they take 10% profit. If they lose, they will pay. This is how they approach the issue. Whereas all of the consulting world approaches the view very different. No, 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 no. It's bad. You have to give. Having not give, you're anti-India, anti-investment. It's a whole dump. When you can insulate contractually, why don't you follow what the government also says? What's your problem? Is what we are simply putting to you. So it's a fight against, it's a tirade against the government after contractually putting safety walls for you. You are taking, see, it's an adventure. Risk and reward go together in life.
So, can I build that question a little more, or that line of thinking, and want to quiz you on it? Uh, you also mentioned at the Taxsutra summit yesterday that the world is changing, and that was a recurring theme. In fact, one of the a former CBDT member, Mr. Akhilesh Ranjan, beautifully put it yesterday in the context of Tiger Global, and he was the DGIT when he issued a letter to Walmart when the transaction was happening, saying that you may want to go and check whether TDS is applicable, which they did, unlike Vodafone, which did not. Now, sir, he
But one thing,
beautifully
Arun, one
put
thing,
it.
sorry for the digression. Vodafone also had a similar class, but it was never mentioned
I
anywhere.
understand. So, but so in this case, they actually went and sought for the TDS clarification, so on. So, but Mr. Ranjan put it beautifully that the old world is dying and the new world is struggling. And I want to build on that point, sir. Do you feel that the jurisprudence is evolving and leaving behind a lot of yesteryear decisions because the facts are different? But the advisors are still stuck with Azadi. Do you think that the advisors are not moving in sync with the global thinking and evolving jurisprudence?
See, if they won't mistake me, yes. I said this yesterday in the when Ajay asked this question. This question is, sir, if bona fidely we have followed the law, what are we supposed to? So I gave an answer. It will be a surprise for you to say legal luminaries, leading law firms, dynamic chartered accountant firms, distinguished chartered accountants can plead ignorance of law. Then what do we do here? What do we do? And this is a case post Tiger. It is not ignorance. You are dumping on us. You are calling us as though we are all people who don't know anything. You have taken to that extreme. See, fortunately, whatever is happening in this side, I'm also informed. And they have taken me into contact. I can't be putting it in the kind of things, messages that are getting sent. It's it's very, very. See, you can't shift the blame at this point of time either on the government or on the Supreme Court. There is no need for us to take it. Where it has gone wrong, it is for you to decide. Government is not wrong, Supreme Court is not wrong. That is something which we can sanitize and tell you clearly.
So, do the advisors need to evolve?
No, I don't want to answer that. Let them see. It's for them to know. Who am I to say whether somebody should evolve or not evolve? It's very simple. But I'm making it clear to you. It's for them to take. Government has not done a mistake. We have not done a mistake. We have been transparent for you tried your luck and you failed. And you are blaming all of us and putting so much pressure on us as though we have all done something against your interest. Hey, whose interest here? We just really want to know.
Yeah. So there's also a lot of writing and advocacy for a larger bench on this issue, tax avoidance, tax planning, and other things. So substance, form, whatever it may be. Uh, Do you think it's a self-serving
See,
advocacy?
I never speculate future, Arun. It's my nature.
Do you
So
think there is a necessity for some larger bench, or you think, Sir, Tiger Global gives enough clarity on all the issues?
see, necessity or
So,
not,
let me give a context. I was there for 28 days in the Supreme Court when the Vodafone hearing happened in 2011. And Mr. Rohington Nariman, the then Solicitor General who went on to become Supreme Court judge, he was at his absolute fiery best when the judges asked him, "Do you want us to refer this to a larger bench to clarify Azadi, McDowell, etc., so on and so forth?" And he said that not required, you can decide it. And Justice Kapadia said, "We'll find a middle path." And that middle path was a carve out that you got, not what revenue was seeking then. The reason why I'm asking is that, sir, the larger bench bogey or the larger bench point is not the first time that has been raised. It was raised during Vodafone as well. And when the review petition was filed by department in Vodafone, the 100-page review petition, which I read, I distinctly remember the Solicitor General and the government making it very clear that the Supreme Court had misconstrued McDowell. So now what the trade is saying is that Vodafone has been misconstrued. So I'm trying to put it. So I'm trying to build the argument very clearly with a context which no one is giving. That at that point the revenue felt that more McDowell had been misconstrued.
see, it's very simple. They did the same thing for MFN. They said larger bench, and they tried also. And they filed a review, it got dismissed. They filed one more petition, came up before a different bench. They argued it three, four times, said no reference to a larger bench, they dismissed it. This is the fate which happened in MFN. So, if people try the same thing here, what will be the fate? It can be to say, I can't predict what a bench will say, but I can say today the Supreme Court has not flawed for the matter to be referred to a larger bench. This is our view, very clearly. Why it has not flawed? It has only interpreted the law as framed by the government. And again, government has not flawed because you tried your luck before the government. You see how it's very, very sad. How can a high court say recommendations will override law? How will recommendations substitute law? Therefore, if you wish, you aspire, you try, that is all your game. But the judgment is neat and clear.
So the final question comes from me is what for you is the most important takeaway from the Tiger Global judgment?
See, when I will say what you said 5 minutes before. When the global progression is moving in a particular direction, when the legislative amendments are progressing in a particular direction, when whatever you wanted to somehow get it into the law was not accommodated, and when Supreme Court understands the law as understood by rest of the globe, this judgment is not in sync or is in contradiction to some judgment here. It's not some judgment from some moon or from other planet. So when all these are falling in one line, then if trade is unhappy, what are we to do? See, you can't write judgments to please business. Okay, businessman. See, this is what is happening. See, citizen-centric. This is tax law is one figment. But we are facing this in several branches of law in the Supreme Court day in and day out. Harish Salve's famous statement. When judgments are in their favor, they will say Supreme Court is good. When judgments are not in their favor, Supreme Court is bad. So only two yardsticks. Whatever I get in my favor, I'll call the institution as good. Whatever I don't get, I'll call the institution as bad. If this is going to be the approach, then what do we do? What do we deal with such people? We'll have to leave it them, their choice. Nothing has happened behind anybody's back. Now they only want to somehow ensure this 10% profit is with them. That's all, nothing else.
Okay. So I'll leave Tiger Global aside and we'll close with your closing remarks, sir. You've won a lot of big cases, sir. As modest as you've been, in terms of not taking too much credit for it. So you have 36 years experience on the tax bar among the youngest senior counsels 2 decades ago. Uh, you dealt with a lot of landmark indirect tax cases, then direct tax cases, international tax, commercial corporate law matters. In the jurisprudence in the last 3-4 years, is there a shift in jurisprudence at the Supreme Court over the last 3 to 4 years? And we'll close with this.
Certainly, certainly. See, not only Supreme, see the point. Supreme Court decides the case based on the context in which Asadi was decided in the context of FII. It was never defined under FDI. So your 788, 789, if you have blown it out of proportion to apply for FDI, it's whose call? Supreme Court's not made a mistake because it never had a transaction of that nature. In Vodafone, 2:1. Same, concurring opinion, no conflict. But one deals with a transaction of Cayman Island and says when it can be, what can be done in terms of jar and gar. Another judgment, concurring, says India, Mauritius with no underlying facts. So, how do you deal with it? If you take a risk based on those judgments, it's whose fault? And 3, legislative amendments from 2012 to 2017 carried forward with explanatory notes, with detailed discussion papers, with recommendations, with certainty. So nobody has been put, no surprise here. No, sir. So when these 3 things have been followed, then what is the problem for the trade or their advisors to also fall in line? You want to somehow still fight. You will continue to fight. See, when you have brave to fight in this type of a regime, to say that TRC will still hold even in GAR period, then what do we do? What do we do? When you fully know what the law could be. So, whether it's an investor's mistake or a consultant's mistake, why should we be exploring that here? We will leave it to you. Let people decide whatever they want to decide. So, but don't keep on blaming us.
Not also.
Don't click on. Not when I say Arun, not meaning you. When I say the kind of,
Thanks.
But now I'm quite used to this. Therefore, and government is also more used to this. So there's no problem about it. And let me also close. I should thank 3 people more. My teacher, Mr. P.V. Srinivas, Shekhar, my good friend from Deloitte, and Bala, who is now the Joint Secretary. I have learned all these laws more from them and through whatever opportunities I got. So I should be thanking them also at this juncture. And I dedicate this talk, I dedicate all these efforts to my spiritual gurus, the Saint of Shringeri, and more importantly, my senior C. Natarajan. This moment, whatever it is, whether it's glory, if it is not glory, let me suffer it. If it is something to my credit, I full-heartedly offer it as a dedication for my senior with whom I lived as a shadow for 14.5 years. Every bit of what law could be. Had he been here, had he worked his case and argued for the government, he would have brought 10 times to 100 times more value addition. That is a super brain who was my guru, under whom a figment of which I could draw as a Sishya. I dedicate this to him at this moment, Arun. Thank you so much to one and all.
Many thanks, sir, for joining this session, sir. Thoroughly grateful for your time. It really takes a great sporting attitude to come and face at times hostile questions as well. Really appreciate, sir, coming on the platform and decoding it for Taxsutra readers, patrons, and subscribers. Really appreciate. For all Taxsutra subscribers, we will continue our roadblock coverage of the Tiger Global judgment, and we'll bring you views from all sides. We pride ourselves on being a neutral platform, and we'll continue to bring diverse views on the table. Thank you, sir. Thanks a lot for your time. Thank you. Thank you, everyone.
Thank you once again to one and all. Namaskar. Thank you, Arun. Can I exit?
Yes, sir. Thanks.
Thanks, Sanju, also. Thank you.